It's good now. Okay. You see the record, right?
Yes.
Okay. Is everyone hear me?
Yes.
Yes.
All right. Thank you for joining us at the Amadou Diallo Foundation Forum titled The Grand Jury Process, what changes we need in the Breonna Taylor case and other cases as well. The Amadou Diallo Foundation is excited to have you all. I first want to introduce our board members. We have Graham Waterspoon, Mr. Mohammed, Ms. Sandrine Dikembe, and I know Laura Brown is joined and remotely. So the purpose of having this forum is to really educate the public and join in contributing to the ongoing questions, lingering questions that we, survivors of victims of these heinous crimes that continue to rob people of their loved ones and not receiving justice. I can say the example is my son Amadou Diallo and other many people. So the Amadou Diallo Foundation mission is to advocate for racial equity for African minority community and to promote education for people of African descent and connecting people of African descent. Our vision is to end racial inequality. And our vision also is to promote education for all young African people who dream to pursue higher education, a dream my son had and he never had the chance to accomplish. And today we have a distinguished guest. Casilda is an attorney and an adjunct professor. And we have attorney Kevin Boyle from AU, American University. And we have also attorney Drummond. So welcome to this forum. And we are really looking forward in learning about the topic today. And this is one of the many forums that the Amadou Diallo Foundation hope to conduct to bring our contribution to the debate and to solutions. We are seeking solutions, not just talking, but solution. This is why we have such professional people on the platform today. As guests also, we have Ron Weiss from Skadden Arp, and we have Susan Plum from Skadden Arp. Skadden Arp have been working with us for a long time, and we are proud to be really their friends. And we also have, for our partner, the Amadou Diallo Foundation partner in the Amadou Diallo Scholarship and Programs, Jean Adam from the Bronx Community College. So I want to open the floor and hand over to our event moderator, who is Graham Weatherspoon. Graham.
Thank you. Thank you very much, Mrs. Diallo. It's good to see you all here. And we trust that this is going to be the first of many forums that we will be holding in the oncoming years. I want to give you a little background and then we're going to jump right into the matter of the grand jury. Casilda Roper was born in Panama, raised in Brooklyn. She's a graduate of Baruch College, part of the CUNY system, City University of New York, and she got her Juris Doctorate at Brooklyn Law School in 1994. The resumes of these three people is so lengthy, I cannot read it. They are involved in civic activities, religious activities. They've done pro bono work for so many people, civil rights cases, defense law, and personal injury. Ms. Roper's married. She has 3 children that she is still in the process of raising, but she finds the time to advocate. And we have worked together in the past, and Casilda, it's good to see you here today.
Thank you for having me.
She is a senior partner with, help me. I lost it. Yeah, your firm. You're a senior partner with?
No, I work for the Department of, for the state of New York.
Oh,
and
okay.
I was a administrative law judge and an attorney for the Division of Human Rights. And I've had my own firm for many, many years. working along with my sister, who's now a judge, Sandra Roper.
All right, and you're an adjunct professor as well.
I'm an adjunct professor, 11 years at Malloy College, teaching criminal justice and the paralegal department as well.
Very good, thank you. Our second unit here is Mr. Kevin Boyle. Kevin is a law professor at the American University in Washington, D.C. He's had a full career with the United States Army as a JAG officer, working through Europe, handling cases with the military, up to and including cases where men were on trial, and not only for criminal actions, but they were on death row. But he has been in charge of various units of the JAG unit, the Judge Advocate General's unit of the United States Army. He retired in 2016, and he is a full-time professor at the American University. Kevin, we thank you for being with us today. And lastly,
thank you so much, Graham. Every time I talk to you and everybody else, I feel like I'm home because I hear everybody talking the same as I talk.
That's good.
So I'm very happy to be here. Every time Graham is on the phone, it's the happiest day of my life because I hear a New York accent. So
that's right. He was born in New York. That's right. And last but not least, Mr. Stephen Drummond from Drummond and Squillace in Queens. I have had the honor of partaking in a trial with Mr. Drummond a few years ago. A very adequate tactician in his practice. And we are going to have some very distinguished information coming from him regarding the grand jury process and things that he has executed during his time. He's also a former assistant district attorney in Queens, and he's doing great work in the county of Nassau with his community. He's also on the Board of Appeals. He's worked with the Board of Appeals, done trials in domestic violence and a varied number of things. So I'm going to go first to Kevin Boyle. And Kevin is going to give us a quick, and I'm saying 3-minute background history on the grand jury, where it originated, how it evolved into the US law system, and then we'll get into the meat of the matter. Kevin, please.
Thank you so much, Graham. Well, the grand jury is contained in the Bill of Rights. It's in the Fifth Amendment, where it says, prior to a trial, your case has to be heard before a grand jury. And this actually comes from England, but it's contained in the Bill of Rights. The grand jury was designed as a check in the power of the prosecution. So the prosecutor makes the charges, and instead of going straight to a trial, there's another set of eyes on the case to make sure there's enough to subject a person to a criminal trial. So that's the basis of why there is a grand jury. It's called grand jury because it has more jurors than a regular trial has. A grand jury could be up to 23. So it's spelled in the Fifth Amendment. And originally the Bill of Rights applied to just federal actions where it says Congress shall make no law regarding speech or religion. So originally the Bill of Rights just applied to federal cases and federal actions. Eventually over time, one right at a time was incorporated to the states. So now states have to respect religion. States have to respect free speech. However, the grand jury is one of the very few in the Bill of Rights that the Supreme Court has not incorporated to the states. States technically do not have to have a grand jury. And several states do not use a grand jury. Some states, such as Connecticut or Pennsylvania, use a preliminary hearing. And that is, the Supreme Court has found that is a check in the prosecutor's power. So in those states, it's a public hearing before a judge. The defendant is there, the prosecutor is there, evidence presented to the judge, and then the judge makes a decision. Is there enough to go to a full trial? So several states do not use the grand jury. And the Supreme Court has said that is okay, either grand jury in the federal system, grand jury in the state system, or a preliminary hearing. And that is the check on the power of the prosecutor. Because a lot of times one of the criticisms about the grand jury is the the prosecutor can indict a ham sandwich. That's an old expression, that the prosecutor presents the evidence and the defense is not there oftentimes at the grand jury. So a lot of times the criticism is it's too easy to get a indictment, because the grand jury, if they feel there's enough to go to a trial, they issue an indictment, and then you go to the trial. So often in the past, the argument was it's too easy. However, we've seen in way too many of these cases with African Americans who are having their lives stolen, and I say stolen, way too young, is the transparency, because the grand jury is held in secret for several reasons. The grand jury is held in secret. The arguments are, we don't want the person to possibly flee if they know the grand jury, or we want witnesses to feel comfortable and not feel intimidated. So that's the reason, the arguments of why a grand jury is held in secret. However, as we all seen with Breonna Taylor, I was up at 2:43 that morning. I was up the whole night, and I kept thinking, I want to know what the grand jury saw, because there's not a lot of transparency in the process. Whereas when I mentioned the preliminary hearing, which several states use, there is transparency in that process. So that's a little bit of the background of the grand jury, and then the fact that some states actually don't use it. They use a different mechanism to make sure there's enough evidence to go to a trial.
Okay, thank you, Kevin. Casilda, I'm thinking of the Bailey case that we discussed years ago. And that was a case that did not go to a grand jury at all. It was a matter where the district attorney himself decided that it should not go to the grand jury. Could you speak on that aspect of the system wherein the district attorney chooses not to even present a case before a grand jury? You're on mute. You're on mute. Unmute your phone.
Unmute. It's interesting that you said that, because I was thinking about the Bailey case as the last speaker was speaking, and I remembered that case. We were required to do such a lot to get them to even look at the case, because they were the 4 officers that were involved. And one of the things, the issues that we had is that the witnesses were scared. They were very afraid to even speak with the DA at the time, and they were being threatened and had a lot of fear. From my perspective, from the prosecution at that time, again, it's always extremely political. And when the DA actually is quote unquote in bed with the police department, it's very difficult for them to bring a case against their own, for lack of a better word. And when you keep that in mind, that may have been the issue, because there were 4 police officers. And as tragic as it was, what happened to Mr. Patrick Bailey and his family, you don't know where to get justice. And the federal court at that time was not taking cases like they should have. I remember in the Amadou Diallo case, when I was a part of that, and we were able to get the federal to the federal court, the U.S. Attorney's Office to come in, take that case. That also had some political wrangling, as you will, and the DA at the time actually just said, take the case, I'm good, and didn't even bother to do it in the DA from Kings County. So there were some issues. I think as over the years of being a defense attorney, I know that some of the issues that I have is not really knowing what's going on. And when it's time for trial is sometimes when we get to see the grand jury testimony, if they want to impeach the witness or any of the following. So from that particular case, Mr. Patrick Bailey, again, I think the fact that the DA at the time is very political. And that's what we even see in the Breonna Taylor case. It's extremely political for them to make this decision, because we've all learned, all of us that are part of this system, know that you can indict a ham sandwich. So it really depends, as the speaker said, what is presented and what is spoke to. And I thought what was interesting, and I may be getting ahead of myself, I thought what was interesting is that the Attorney General, the discussion that he had, we're not sure exactly what discussions they have with the jurors, and it's a very powerful position for a prosecutor to have in the grand jury.
I want to give people a little background on the Patrick Bailey case. He was a young man who was shot by police officers in Brooklyn, New York. in 1987, October 31st, if I remember correctly.
1997.
What was it?
1997.
Oh, 97, I'm sorry. And he was shot in the back. Long story short, they alleged that he had a weapon, which he did not have. He was shot in the back. The bullet traversed through his body, through the femoral artery of his left leg, and he bled to death. The thing was that the officer who shot him is named Kenneth Boss, and he was one of the officers that also shot Amadou Diallo 15 months later. And the DA in that case, in the initial case, chose not to do anything with regard to the shooting of Patrick Bailey until at least a week after Amadou had been shot.
The thing about Patrick Bailey case also is that the report that was made on the 911 is that Patrick Bailey had a gun. And when the police came, he ran inside his mother's home and actually closed both of the doors, and the doors were kicked in, and police officers can use deadly force, of course, when they say exigent circumstances or they fear for their life. And at the time, Mr. Bailey he ran down the hall, and as he turned to go in the basement is where they shot him, and the trajectory of the bullet ended up in his groin area, and he died and suffocated, unfortunately, very sadly, from bleeding to death inside. So what happened is when we started doing the case, we were not privy to the names of the officers. So in even filing this notice of claim that's required in these type of cases, they were named Police Officer John Doe. And on the day, unfortunately, the morning of Mr. Diallo being shot, I started receiving a lot of phone calls from the press, and it was bombarding my office, and my secretary at the time, Mr. Simpson, Dennis Simpson, called me, and he says, they're trying to speak to you. I said, about what? So I eventually called back and I said, what's going on? They said, how do you feel about the officer that shot Mr. Diallo, who also shot your client? I said, they never gave me his name. So even on the onset on some of these cases, you're not even privy to the name of the officers. So if they won't give you the name from the legal perspective, from the civil side, from the DA side, it's even harder, because again, we have to keep in mind, and there's nothing wrong with the system. The system is what it is, but at the end of the day, if the prosecutor has such a close relationship with these police officers, then how do we really know the validity of them making their decisions?
Thank you. The politics, which should not be involved in the judiciary, but it is there. Mr. Drummond, you've handled many defense cases, and in the grand jury process, the defendant does have the right to testify before the grand jury if he or she chooses. You have extensive experience in that. Could you speak to that aspect of the grand jury process?
Absolutely. First of all, thank you, Mr. Witherspoon, and good morning to everyone. And I just want to start out by commending Ms. Diallo for taking a very tragic situation in her whole life to help many of us and to help many people. So I want to say thank you so much for that. I've been a former prosecutor in Queens County. I was a prosecutor there for 4 years. So I presented a number of cases to the grand jury. You do end up having a good relationship with the grand jurors because they're convened for 30 days. So the first week, if you want to present a case you'd say that's a challenging case, you probably won't want to present a very challenging case in the first week, because grand jurors in the first week of a grand jury proceedings tend to think that they're there to prove the guilt or innocence at that stage of the person. And there's a lot of investigative questions at the first week of the grand jury. By the second or third week, they start understanding that's a probable cause standard. And it becomes easier for that indictment. As someone said earlier, you can indict a ham sandwich. It's more, I guess, that they understand they're more likely than not. Anything over 50% means you must indict. As a defense attorney, my law partner is on the line. We have put 23 witnesses in the grand jury. We have been successful in securing a no true bill 17.5% of the time. And the 5% meant we actually hung, under her leadership, actually hung a grand jury. I don't think you hear that often. You hear about regular jurors being hung, but I'm not aware of any other situation where a grand jury were hung as a result of presenting. In that situation, we very carefully screen what cases we put into the grand jury. And that's why we have such a success in doing it. And in that proceedings, the defense attorney just gets to sit there. You don't get to ask any questions. You prepare your witness before, and you cannot interrupt. The occasion the witness could come to you and ask a question, but that's very much controlled, because you don't want a situation where the grand jury thinks in the midst of the witnesses testifying, you're the one that's guiding the testimony. So we tend, in the cases where we're presented, we tend to make sure that the witness doesn't really ask us a lot of questions during their proceedings. It's very his show or her show, and you sit there and just watch the proceedings.
Thank you. There is the belief that the panels should be secret. I think there are 3 states in the union where the grand jury process is not a secret panel. And no threats have ever been made against a witness in any of those states where the process is open. How do you as attorneys feel? I know Kevin had mentioned the fact that one of the reasons why they keep it secret is that for fear that the defendant might flee. But what do you think with regard to having the panel secret as opposed to having them open, as we see with the Breonna Taylor case, where we really don't know what was presented, as also in Staten Island, when Eric Garner was killed, they came back with no true bill. And the question there was what information was presented to the grand jury, and the fact that you have 4 or 5 officers acting in concert. What do you think, Kevin?
That's a great question. Thank you very much, Graham. I think everything needs to be transparent. Nobody can have faith in a system of justice if they don't know that system of justice. And I go back a little bit to think of my military career. Military is in the federal system, but they do not use a grand jury. They use what's known as an Article 32 proceeding under the Uniform Code of Military Justice, which is a preliminary hearing before an officer. The defendant's there, the prosecutor's there, all the evidence is presented, it's open to the public, and then there's a decision, should we go to a trial or a court martial? And I'm used to that system, and I like that system because there's faith in the system, because everybody knows what's happening. The same thing with grand juries. The arguments that people make about why it has to be secret, I'm not sure how valid they are. People say, well, the person may flee. Okay, well, then how are you going to get him to trial eventually if you think he's going to flee? So I think the public will not have faith in our system of justice if they don't know what our system of justice is doing. Think about trials. Imagine if all our trials were held in secret, right? Now that we have court TV and other mechanisms where people can actually watch a trial, people understand the criminal trial process a little bit better. Imagine if all our trials were held in secret. I mean, nobody would have faith in the system. Now people don't have faith in the grand jury system because everything's in secret. The whole night I was up saying, I want to know what that grand jury heard. And it's hard for people to make decisions on what they don't know they're making a decision about, or making, the public, it's hard for the public to say, we support this decision, we don't, if we don't know what the decision was based on. So I think the system has to be open for public to have faith in the system.
Stephen?
Well, so that's a very great question, Graham. And ultimately, it comes down to this in my assessment. Balancing the public needs to know versus the government's right to pursue justice. I've served as a prosecutor, and I'm also in the JAG Corps now too, so I'm familiar with both sides. If you take a case, let's say you have an international criminal, someone who's a drug lord in some country, and you start presenting that case to the grand jury and you make that proceedings public, it's very unlikely, once you alert that person, it's very unlikely that witnesses are going to come forward, and it's very unlikely that ultimately you're going to get that person for trial. So my sense of it should be, just as out in narcotics cases, when I served as DA, I prosecuted a number of narcotics cases, dealt with a number of undercover police officers. You make an application to the court to seal the courtroom at trial. where you have a witness whose identity is so important that you don't want the public to get access to it. And the court assess the government's right to present the case and the public's right to know and make a determination based upon that. So I kind of look at it from that angle in terms of how the grand jury should work. I think the court should be allowed to, the prosecutor should go to the court and say, look, on this particular case, before we make presentment, we want to make it secret and outline the compelling reasons as to why it should be secret. Then the contrast should be evidence being presented to establish why it shouldn't be secret. And the court makes a determination just as it does at trial. We have in our system, not only with narcotics cases, but with special victims cases. If a little girl or little boy is raped or molested by someone, we have a system where you apply to the court and say, look, the right to confront this witness, as in the Fifth Amendment the defendant has, should be subdued, because exposing this young boy or young girl to seeing this person in the courtroom could cause them great trauma. And the court look at those cases and make a determination where witnesses sometimes testified in a closed setting that they cannot see the defendant and the defendant may not see them. So we have in many ways that process already in play. It's just a matter of now getting the grand jury to say, look, across the board, all cases shouldn't be secret because there's no risk of fleeing. And the other point I wish to make on it is this. Sometimes cases are presented to the grand jury and the defendant or the subject of the grand jury proceedings was already arrested. So the idea that he's going to know and flee and things of that nature, that's gone because he or she is already arrested. And he or she has a right to testify before the grand jury once he or she has already been arrested. So the notion that let's keep it secret because a subject of the grand jury proceeding may flee, that's completely undermined by the fact that the person is already arrested. But I just don't believe it should be a blanket situation across the board that all grand jury proceedings should be known to the public, because the government can establish, I believe, a compelling reasons as to why it shouldn't be. And in those cases, we have to balance the public's right to know versus the government's right to pursue justice.
Thank you.
Can I follow up real quick, Graham?
I'm sorry?
Can I follow up real quick?
Okay, I want to get to Casilda. Go
Sorry,
ahead.
Stephen, outstanding points. And what he was talking about, certain times you should be able to keep things secret. And the military does as well when there's a case with classified information. The entire trial is not closed off. It's just you have to use a scalpel and section off that part of the trial that has to be closed off. And you make an application to the judge, and judge hears both sides. But the judge will not totally close down the trial, just that part that has to remain secret. So Stephen brought up excellent points. I just want to agree with him that he brought up great points.
Thank you. Casilda.
I agree with wholeheartedly with Attorney Drummond. And I take it from the position also, and my premise is when we're sworn in as attorneys, we have to uphold the Constitution. It's the basic. And it's we the people. So yes, there's some issues with the secrecy, but when the prosecution or the prosecutor goes into the grand jury, they can't be self-righteous and take it upon themselves to do what they want to do. They really should provide the information as thorough as possible for the grand juries to make that. You know, one of the things that I've learned over the years in my classes with my students, they always say, well, the system needs to be reformed, but where do we start? And all of the things that Attorney Drummond articulated are excellent, but who's going to buy into it and how do we get them to buy into it? But at the time that we have the system that we have now, we have to hold them accountable, hold the prosecutors accountable to presenting that. And I agree that perhaps, you know, I've had trials that were sealed and not sealed. I've had young people who were afraid, domestic violence people, and we had in-camera presentation. But in the grand juries, the prosecutor is also the judge, because they also determine the charges. They also determine the evidence, and sometimes some of those evidence will not even be admissible in an actual trial. So there's no objections to be made by the defense. And the other thing, you know, along again with agreeing with Mr. Drummond, when we prepare our defendants to go to the grand jury, when we prepare the defendants to go to the you know, you have to be very careful how you do that, because again, the discussion section, even as we've seen with the release of the Breonna Taylor case, we don't know what's going on with the discussion with the DA and the grand jurors. So I think it's an excellent question, but I think again, the secrecy, even if it stays, they have to be held to their standard, and it's we the people. They need to make sure that when they go in, they are the people of the state and not themselves and not individual issues.
So
Thank
let me
you.
just add one quick comment regarding it. It might seem from the outside perspective that prosecutors have a great relationship with the grand jurors, and that might affect how things work out. But you're also very guarded, because you also have an obligation. You're first and foremost officer of the court. So you have an obligation to protect yourself, because in the back of your mind, if you're presenting cases as a prosecutor to the grand juror, you also have to be mindful that it's easy to put someone in there to approach you as a prosecutor to see if you're playing by the rules. That's not removed. So you can't just say, well, okay, this one likes me and that one doesn't like me, and try to get along with them and hope to get an indictment by virtue of some relationship or like or not like relationship from a grand juror. And the second point is there's a check and balance to this whole thing. You are charged with responsibility of charging them on the law. You get to assess what questions they ask and what questions you're going to allow. You're given great responsibility as you present a case to the grand jury. But ultimately, in the back of your mind, you know that a judge is going to get a chance to view and view exactly what you did and didn't do. And you have to be very cautious about that, because after an indictment, there's a motion coming. The defense attorney files a motion, and you don't get the grand jury minutes as a defense attorney at that stage, but the judge gets them in camera to assess what you did and what you didn't do. Look, it's a small district attorney's office in the sense that reputation is established real quickly. And a judge looking at what you did and didn't do at a grand jury, that travels around. You don't want to be the prosecutor to have developed a reputation of playing with the grand jury proceedings. And one final point, even after, as a defense attorney, you then get, we call in New York, Rosario material. Ultimately, you get some of the grand jury minutes anyway, if the prosecution intends to call a witness at trial.
That's very.
And if you get it way down the road on the eve of trial and you see something, we have filed motions late in proceedings. In New York, you have 45 days after an indictment to file your motion. But we have filed motions way after, when we get the grand jury minutes and saw that something in it was improper, and we have been successful in that endeavor. So because I know there are many people listening, I want to make sure that there's an understanding that there's some checks and balances already in place. It's not just the proceedings are secret and there are no checks and balances afterwards. Judges play a very critical role, and judges have dismissed indictments repeatedly where improper conduct occurred in the grand jury. It happens a lot. It's not, there's a little check and balancing in place, but the public needs to be assessed from where we are now, particularly in light of the current climate.
I agree that the checks and balances exist. But again, keeping in mind of the Breonna Taylor, for instance, there are discussions that transpire between the prosecutor and the grand jurors that the judge will not have privy to. And there are also a lot of body language speaks a lot, and that's not captured in a transcript. So although I agree with you wholeheartedly, Attorney Drummond, but in the same sense, we have to be mindful that checks and balance doesn't always weigh the way it needs to. And we do have a lot of judges who should be impartial, but not always are impartial. So what is that check and balance? And that's why it's important to make sure that when you take your case, you have your defendant ready to go to the grand jury, and before you file the 190-50 that's required, it's really strategic from a defense perspective, because we try to wait till the last day to see who the witnesses are, because sometimes the prosecutor doesn't even want to even tell the defense attorney what the witnesses are. And I agree with you about the Rosario material, but oftentimes a lot of prosecutors play games with the Rosario material and act like they gave it to you when they didn't. And the day of trial, you realize that you don't have it. So, you know, that is entirely true. But the grand jury, again, the criminal justice system needs to reform in every aspect and every level. And it's when and how we're going to do that, and what process are we going to take to do that. This forum in of itself is a perfect example of having that and getting the information out there, because oftentimes people are not aware of the criminal justice system until they become a part of it.
Thank you. Those are excellent points. We have seen in the past, for instance, I know, Kevin, you have ties to Ahmaud Arbery's former coach, his high school coach. And we all saw that case. I'm sorry?
Yes, Coach Jason Vaughn, wonderful guy.
Mr. Vaughn, yes. And in that case, we had retired police officer, police chief, and the DA, each of them covering for each other in a matter that should have been brought before the court subsequent to the shooting. So the need for reform is there. And it was months. The only thing, the blessing is that through technology now we're finding out about these cases.
Mm-hmm.
And I don't know if Mr. Vaughn made it on today. He was supposed to join us. But that case in particular is very striking, because the DA's job is to advocate for the victim or the victim's family. That is the only advocate that the victim has, is the district attorney. What about presentations where information is withheld, which is beneficial to the defendant in a case that is going into a grand jury? I understand that there are times when the DAs will withhold information that could exonerate or bring serious question as to the validity of the arrest or the involvement of the individual. And that is not presented before the grand jury.
I think that the thing we need to be mindful of is that the prosecution, the DA's office, represent the people. And keeping that in mind, help me with the word. Any evidence,
Exculpate.
Thank you. Any evidence that will show the defendant didn't commit the crime, it's imperative for them to put that in the grand jury. But again, because the prosecutor can choose the evidence that he or she wants to place into the grand jury, that's the problem. And the checks and balances, according to, I agree with Attorney Drummond, happens, but now the grand jury is already done when the judge is looking at this. And they decide what relevancy and what evidence go in. And they may even put evidence in the grand jury sometimes that will not even make it to trial, because a skilled defense attorney would fight like the Dickens. So that's the issue. How do we know what's going in there? And because the defense attorney is never allowed in there until he or she actual client testify, then that's the problem. So if they have that type of information, they're still supposed to pass it over, even quote unquote with Rosario, and even through the discovery process of the criminal justice process, CPL, and so on and so forth. So the question is really, again, my basis and my premise is the prosecutor, we're all officers of the courts, it's we the people.
Okay.
Graham, yes, this is Joanne. If I could just follow
Hi,
up
Joanne,
briefly
yes.
on that. Hi, everyone. First, I hope,
this is
as I
Mr.
said
Drummond's,
earlier,
Mr. Drummond's partner. Go ahead, Joanne.
it's a pleasure to be here with all of you. And again, I hope everyone is staying safe and well. Just to follow up on that, and Graham, you had mentioned the Eric Garner case. That was an interesting case. And to follow up on the premise that the prosecutor gets to elect what evidence they put forth before a grand jury. As our skilled defense attorneys have said, typically, if you're arrested on a criminal court complaint on a felony, in order to be prosecuted and go to trial on the felony, you have to be indicted on that felony. That criminal defendant is going to know that he's going to be the subject of the grand jury. He can assert his rights, or she can assert her rights to testify. And so the issue of those proceedings being secret, the reasons behind keeping them secret don't really apply, because the person already knows what they're being charged with and accused of, and they can in fact defend themselves to a certain degree in the grand jury. Then you have those, as Mr. Drummond said, often in narcotics investigation cases where the government and the police do not want the suspects to know that they're a suspect and to protect the integrity of the investigation. to help protect witnesses, prevents a suspect from fleeing. The grand jury proceedings are held in secret, and then the person or persons are arrested on the indictment. They've already been indicted. Now we have the issue of Eric Garner and Officer Pantaleone, where he was not arrested on a criminal court complaint to then be presented before a grand jury and assert his rights under CPL 19050 to testify. But rather, the prosecutors in Staten Island decided to hold the grand jury proceedings and call him as a witness. So he got to testify before the grand jury to determine whether he would be indicted or not without being arrested already on a criminal court complaint. And as we all know, there was a no true bill. There was no indictment. So those proceedings are forever secret. There is no Rosario that's going to be turned over because he was never prosecuted. And technically, can the government, can the people, can the district attorney's office call the witnesses they want to call, including the potential defendant? Yes. But when the issue now of transparency and why there's distrust with the public, are those proceedings really transparent when we don't know what Officer Pantaleone testified to? Why was he called as a witness? Why did the prosecutors decide to call him as a witness? And is there a way within the rules that a prosecutor's office can steer an outcome that they so desire? And I think the Eric Garner case brings up that very point, and that's why the public at times has such distrust in the system.
Well, here's the other thing. When you call a witness into the grand jury and they may be the subject of the actual charge, there's usually immunity sometimes presented to them. So that could have happened under those circumstances. And again, agreeing with Ms. Joanne, agreeing with you that where's the transparency? And now because of his testimony, that particular officer is not closed under secrecy and fear. So those are the issues. There are a lot of issues. Listen, we don't have the best criminal justice system at it is, but we do have the best in most, compared to most other places. But again, who are we asking to start making these reforms, and where are we taking these steps, and what role do we play?
You know,
Well,
go ahead, Mr. Drummond.
Consider having some of the guests to comment or ask questions.
Oh, yes, the chat window. Sure. Go ahead, Mr. Drummond.
The short answer to that is that comes to our, as everybody knows, our elected officials. And Ms. Kulachi brought up a very valid case that the public's interest in such a case is so compelling that the need for the government to have a secret grand jury presentment should be undercut. So in a case like that, that's a classic example of balancing the public's interest to know versus the government's need to create secrecy. There was no secrecy in that case because the officers are known. It was captured on tape. And in situations like that, it's clear that it would be better in the public's interest if such a grand jury presentment was open to the public for the public to know, because this level of mistrust is really a challenge. We can't have a system of justice where folks feel like there's some secret, there's a onerous relationship with the district attorney and the police officers, and that there may be a failure to prosecute, and justice is not measured from that end. It goes back to what I said originally. You look at it on a case-by-case basis, you challenge it to the courts for a judge to make a determination as to whether or not you should get a secret grand jury presentment versus a public grand jury presentment. But that decision comes to, in New York, our legislature, and I think it's right time for such a measure to be brought to them.
And the other thing that I think about are also the jurors. And in picking juries over the years, they have their reservations about even serving on a regular jury, much less a grand jury that can sometimes be so, full of information and fair. So when we think of the jurors and no longer making the grand jury secret, there are people who really love to go to the grand jury as opposed to a regular trial jury, because the regular trial jury is very public. Folks come in, they see you, they look at you, they want to see your body movement. And the grand jury is very, quote unquote, relaxing. And they can have no fear. I know in the Breonna Taylor case, one of the grand jurors want to speak out, but her reasoning, his or her reason for speaking out is because they feel like they're being thrown under the bus by the attorney general. And that's not quite what happened. So again, it's a whole process. And agreeing with Mr. Drummond, that is the legislator, but oftentimes we hear in some of our communities, oh, I can't be bothered with politics. I don't want to be bothered, but it's a connection to our criminal justice system and so many other things.
Can I join in real quick?
Go ahead.
Yeah, great points. And when you talk about, I don't want to be bothered by the criminal justice system, most people in their lives know about the criminal justice system for what they see in the TV and the movies. Most people are not you're called to jury duty or a witness in a crime. Most people make all of their decisions about the criminal justice process based on the media. And that's why forums like this are so important, because of education, to let people know what the actual story, is. Attorney Drummond brought out great things that we never hear in the media. So this is a wonderful opportunity, and the more that you can educate people, and then people are educated, they can make informed decisions when they vote. You don't want people to make decisions based on emotions or what they saw on Twitter. You want people to be educated, and that's why Attorney Drummond has brought out so many great points. I want him on the news tonight, talking. He's brought out so many great points that we don't see. And people get their idea of how a case happens from Law and Order or Blue Bloods. So I think forums like this are so important to educate everybody. I say I got about 25 of my students on. So the more we educate people, the more we can make reform. A good friend of mine, he's talked to my other classes. He says, we got a good system, but it's the people who run the system we need to change.
Speaking of the people, I understand in New York that district attorneys have immunity from prosecution. That's somewhat troubling when, as in the Eric Garner case, the district attorney exercised the maneuver, although not moral or questionably on the ethical side. He may have done something that was within the scope of the law, but never should have been done in having the officer come and testify when he wasn't even charged. This does a disservice to the deceased and the deceased family. And I find it to be further abusive to the victim. When I was a detective, I felt it was my job not to get the facts on a case, but to get to the truth of the case. And there were people who were arrested. I was able to prove that they did not commit the crime. But it is really questionable. And it brings a great degree of distrust when we see the representatives of the court acting in this manner to prove a great disservice to the victim in a given case, especially if you're supposed to be advocating for the victim. It's the issue between the police and the district attorney is one thing. People understand that, but when a person crosses the line, they have to be dealt with, or should be dealt with. The state legislature in New York says that it is an affirmative defense for a police officer to state that he or she was in fear of their life, which was the reason why they took the life of an individual. That, through the state legislature, proves to be a great disservice to the general public, because being afraid is not a justification for killing somebody. You all walk around without a gun. So if the people with the guns are scared, everybody else should be scared. And if everybody else is scared, that should give them justification to kill somebody because they may have looked at them wrong or tried to do something to them. But here in the legislature, the judiciary, and the general public are going to have to be brought together to resolve these issues. And another thing people don't know is that there, in the state legislature, there are lobbyists who work full time to produce specific laws. And some of those laws are for the benefit of the working police officers. I know it for a fact. I have a friend who was a lobbyist here in New York for our union. So it is another reality that people don't know about. that there are professional people working to have laws placed on the books that you never see or hear about. And during my tenure, I had cases where police officers committed crimes, and I had to make sure they were prosecuted and sent to jail. So as this goes forward, what would you say are the steps? I know you all are attorneys, and I believe you spoke about the legislature, the attorneys, and the people, which is the biggest factor. All of the people we have in government come from society, and all of the ills of this society can be found within every profession.
Running a very interesting Zoom conference with lawyers on the criminal justice system.
I thought I heard the voice on it. Sounds familiar.
Yeah.
I'm sorry, is that Fred?
Oh, I'm sorry. I thought I was mute. I'm sorry, bro.
Okay, no problem. Okay, mute your mic, please, Fred.
What I think, Graham, is you spoke about the legislator, you spoke about the law enforcement, and you spoke about the people. And I come from the school of thought where community service has been always what I needed to do for my community. And in doing that, it's imperative for us in our community, social workers, police officers, they have the PALs in some of the communities. We need to educate our community. And I don't mean ours in terms of individualizing the community, but I mean just educating on the basis of school. Mr. Boyle said his students are here. And we have to pass it down to our young people, because we can't have all this gem and not pass it down and hold them accountable. And what needs to happen is that they need to get involved, that we can't have them shy away from being involved politically. We can't have them shy away from participating in elections. It's imperative that we tell them. I have my 3 children, and from day one, I've always made it very clear to them what they need to know and how the system works. And the system was never really built for people of color. And we have to keep that real. So when we think back even to the 13th Amendment, it wasn't really built for the people of color. So all of that we do, even as defense attorney and prosecution, and I worked in the DA's office in a homicide as a paralegal. So I've been on that side and understood the whole process. But all that we do, we still have to come back to the people. And the people are the ones who put the legislators there. And if they don't do their job, vote them out. So it may sound extremely simplistic, but to some extent it really is.
We have a question.
Sorry.
From Diane. Since the prosecutors and district attorneys have immunity, how are they prosecuted for blatant misconduct?
So I'll take that. But before I do, I'll just give a quick plug to Mr. Witherspoon. My law partner and I tried a very serious murder case, and he was a great witness that anyone on the panel needs someone to guide witnesses how to prepare to testify. He's an ideal person, as he mentioned, with his years of police experience. I think now that time is wrapping up, I want to make sure that I mention that. Remarkable witness. The question now is, how is it that prosecutors are held accountable? This part is important to know. You get in serious trouble as a prosecutor for Brady violations. There's a system in place that challenges your admission to the bar. And if you're one who hide things and have a reputation of hiding things, and I say there are checks and balances, but there are many ways there are other checks and balances too. Every judge in every county has a reputation. Every prosecutor has a reputation. If you hide stuff day 1 and day 2 and it gets out, and when you get in trouble for doing it, you have a lot to pay. So there's that one check and balances. The other point is you should have immunity as prosecutors and as judges, because if people were going to be held personally liable, and when I say immunity, talking about people could sue them for discretionary decisions, then people are going to go to work in fear of making sure that they make the right decision. Mr. Boyle, I don't know what rank you retired at, so I say Mr. Boyle, but I'm sure you can appreciate that a commander making decisions on a battlefield needs to have that discretion. Now, if he's negligent or he or she's negligent and you have a different standard, you could charge someone for negligent homicide. And you could say, well, it's clearly reckless in that decision making. But the immunity isn't blanket immunity. The immunity is if you're acting within the scope of your employment, making discretionary decisions, you shouldn't be held personally liable for that or run the risk of going to jail for discretionary decisions. Blatant misconduct, hiding stuff, lying, things of that, you're not immune from that. So we have a system in place already to say, look, one, if you're doing bad things, you're going to get in trouble with the bar. If you're doing criminal things, you can get in trouble. But the other aspect of it, we want to be careful because we want to give prosecution the fair opportunity to present cases without running the risk of getting in trouble. And finally, I know we have cases where people are engaging in grave, grave misconduct. I fundamentally believe that the bad people, you already know them. They're known within the circle. A person doesn't get out the first day and just start going from 0 to 1,000. They tend to start off by doing little wrongs first. So the final point I would make relative to police officers, I would suggest as part of the checks and balances that we hire higher standard for the police officers who see something and don't say anything. And that's something that Colonel Boyle, I want to say Colonel Boyle, I just have a feeling I should say that. That's something that, you know, in the military, if you see something, you have an obligation to say something. And if you don't say something, there are times when you could be held more responsible than the person who actually did the act. Because saying something and reporting wrong is very, very important. And I'm so glad we have cell phones for our world today. That to me is one of the best inventions towards our judicial system, because that has served so well and it continues to serve well. So I hope more people use it and more people get in trouble. But the police officers, the ones who do wrong, should get in trouble. But the ones who remain silent and fully aware of someone who's doing wrong, I think we have to extend that to them also.
Those are great points. And if I could follow up, first, Attorney Drummond, you're going to get a phone call in about 10 minutes. And when this ends, ask you to talk to my classes. Because you're so good. But to follow up, the immunity issue you brought up is another thing that people see in the media and don't understand all the facts of the immunity. You know, and it's not just district attorneys, it's a lot of jobs. You know, a firefighter, for instance, doesn't want to fear putting an axe into the top of a roof of a house, forgetting, because I might get sued. So the immunity is almost a whole nother forum, Graham, if you want to set that up, because immunity is another thing that gets a little misconstrued in the public. But going back to the earlier question about comment about voting, voting is so important and knowledge is so important. People don't even know who their district attorney is. The district attorney controls everything. The district attorney, especially in your mandatory minimum cases, becomes the judge and jury, because if once they make that charge, the judge's hands are pretty much tied as far as the sentence. But if you ask the average person in Nassau County, who's your DA? I don't know, but you voted for them and they control your whole system. So the part about knowledge is power and educating people, because they are voting, when they go in that voting booth, a lot of times they're thinking, oh, I'm just voting for the president. You're voting for a lot of people who have a lot of impact on your day-to-day life that you might not even know. And most district attorneys run on a tough on crime platform, and a lot of them just get reelected. The incumbent gets reelected. So you got to know who your DA is, and you got to know who's running for DA. Up in Philly, they're doing a great job. They have a DA who's more reform-oriented, but dovetailing on that issue about teaching your children, make sure you know the platform of the people you're voting for, and make sure you know who those people are.
Yes, when you speak, Casilda, you were going to say something.
Yeah, I agree. I absolutely agree with both Attorney Drummond and Mr. Boyle. And I still am from the school of thought that when it's we the people and they have an obligation, and I agree that they should have immunity, but as a defense attorney, you have to hold them to that. You have to make sure that when they do and say certain things, even sometime in closing statement and closing argument, that you make that objection. Because if you don't make the objection, then no one's really seeing. And I know we have the appeal process, and folks may think, you know, let's not talk about the appeal. But look at the DA in Brooklyn. How many cases in the integrity unit has been overturned and people have been freed? We're talking 20 years of folks being in there. And I agree about the cameras, you know, other than me being a selfie queen. I agree with that. I agree with the cameras because years ago, things were happening, police brutality cases were happening, and it was just so hard to get the judges at arraignments to even see that this person was beat up and who beat them up. So, you know, and back then we had to put it on the record before the cameras. You had to literally have them lift up their shirt, show the bruises, identify the bruises, and so on and so forth. But then ask yourself the question, if that's done in arraignment when the prosecutor's there, are they taking that to the grand jury? No, probably not, because they don't want to show that they were beaten to even enforce the arrest. So I go back again to, it's our community. It's who we put in place. We have to inform our people. And I say young people, there are a lot of older people who had no clue. I've had some parents with their children come in on the day of a day of appearance, and they were like, who's that judge? I said, you live in this county, did you vote? And I know that some judges are appointed, but there are some judges that are voted for, but you know, and this particular judge they were speaking about, this judge was voted in. So again, I'm sure I come from the school of thought that I want to make sure that the community is informed. And this forum, to me, I can't thank you enough, Mrs. Diallo, for having a forum of this nature and for all the people that are part of this, because it's imperative that it gets out to the public. We must educate ourselves. Knowledge and information is power.
We are absolutely grateful for your contribution today. We have been enlightened by your messages. And I just want to make sure that those audience who have their mics muted, you can unmute and let Mr. Graham Witherspoon know if you have a question or comment, because this is so important and precious.
Yes, if you would raise your hand. Sandrine, you can catch that? Sandrine?
I see in the comment, there's a comment from Roberts. We must educate our, no, it says, can complaint determination to the Civil Complaint Review Board be part of cases of police brutality?
Yes. Well, let me go back to the Civilian Complaint Review Board. They have sought to add more teeth to the New York City Civilian Complaint Review Board, whereby they can issue subpoenas and also impose a penalty. It was always at the discretion of the police commissioner as to whether or not he wanted to penalize an officer following a civilian complaint. And I have a friend who was one of the attorneys on the Civilian Complaint Review Board. And he said the problem was that it would take 7 to 8 months for a case to be reviewed before it was even dealt with, because the attorneys are not full-time attorneys. They're attorneys such as the ones we have here today, and they look at those cases in their spare time. Subsequent to doing their daily work, they'll review it, and then it's passed to the next attorney on the panel. So when a civilian complaint is filed, and I've done this with people, a gentleman who was the victim of an assault by an officer who maimed him, literally, broke a bone, and that arm was no longer fully usable, and played Russian roulette with the guy. I had him file not only the civilian complaint, I said, but this is your triple threat. I sent him to the district attorney's office, to the district attorney's investigation bureau, to the chief of that bureau to open a complaint with the district attorney. Then I sent him to 26 Federal Plaza to open a complaint with the FBI and the Civil Rights Division, and then to file a complaint with the Internal Affairs Bureau. So he had 3 checks and balances, and I told him, don't let any of the other units know that you've been there. That officer was arrested. He did serve 7 years. But the civilian complaint unit it doesn't have the teeth that we would like it to have in making the recommendations that an officer's job be taken. And then another aspect we haven't even looked at is the PBA. Or the
We have one question, Dram. Do you think that the repeal of Section 50A on the New York Civil Rights Law will have an effect on the grand jury process?
I will let you.
You can put that to our guest.
Yes. 50A. That 50A that don't know, that is the background and history, behavioral patterns of the officer following an incident. We always get the 411 on the defendant. Oh, he's arrested 20 times, and they poison the jury pool by putting that in the press, but they never speak of the behavior of the officers. So I'll ask the attorneys, what do you think of 50A with regard to the officers? Should their past records be made known?
In the past, what I've done in handling cases, police brutality cases, or any case that involved any type of personal injury to my client, the 50A didn't impede me from looking up if there was any federal cases against the officer in the past. And I've done that. And so I think there's some issues about personnel and whether it's fair, but it's again, transparency. If we have an officer that keeps, that's doing, and by no means am I saying that all police officers are bad. I'm not saying that at all. What I'm saying is that if we have officers that are not doing and holding the standard that's required to protect and serve, then the public should know. Now, if it'll change the grand jury process, I'm not sure, but maybe, because it adds to their credibility if the officer is credible of what he or she said. I remember with the Amadou Diallo case, they called the Civilian Complaint Review Board to make a complaint. They dropped the ball while Mr. Luima was in the hospital, wrecked. So again, it comes back to my premise, and the basis for me is it's up to us. And even when you call IAB, I had a grandmother in one of the precincts in Queens that was physically assaulted in a precinct by a bunch of police officers. And when she was there with her daughter, I didn't even know until they spoke to IAB, and the daughter called 911 in the precinct. And I remember saying to the daughter, I said, well, why'd you call 911? She said, who else am I supposed to call to help me? She was in the middle of a precinct being assaulted with her grandmother. So again, we go to the point of how do we even know who's telling who what's doing what? You know, a lot of my students are police officers or want to be police officers. And some of the stories they share to me are very interesting. But it's a tough job, and no one's taking away from that. Being an officer, being a law enforcement, it's a tough job being a prosecutor, because oftentimes, even as defense attorney, we can't show our emotions, we can't show our feelings, and we have some really tough cases to deal with. But the criminal justice system, Lady Justice is supposed to be blind, but is she really? Because there's so much bias on every level of our criminal justice system, which is law enforcement, the court system, and corrections.
Let me read 2 messages. Why is the position of DA partisan, and should it be? And the second comment is, I believe that the 50A applies to the release of an officer past agency disciplinary records. So those are the 2 chat. One was the question about the position of a DA partisan, and anyone.
The DA is elected by each county, and they run on a Democratic or Republican or an independent platform. Casilda didn't mention it, but her sister was very much impacted when she chose to run for district attorney in Brooklyn. The sitting ADA at that time was Charles Hines, and he did everything within his power, not only to stop her, but to try and take her license from her.
Right.
And that showed the corruption within his office at that time. And we're still seeing the residue of it, because as Joanne had mentioned, people are being released from prison who were falsely accused and spent decades in prison for crimes they did not commit. I don't personally, well, I'm not the attorney, so I'm not going to speak.
Well, as it pertains to my sister, not only did she prevail, and not only was it very clear as to what was happening politically there, my sister's now a sitting judge.
Right.
So again, it comes back to the people understanding what's going on and be informed.
Mm-hmm. Can I follow up on that and kind of combine 2 things? One is you have to remember the DA is an elected position. All the assistant district attorneys, they are not elected positions. the question about the police officer's background. And this goes back to knowledge is power. I mean, and I kind of take my lawyer hat off, because as a lawyer, you know, we kind of think differently. The first night of law school, they say, I say night because I went to night school, but the first day of law school, they say, when you leave here, you are going to think differently. And you do. So I kind of think, you know, the question about should the grand jurors, you know, have information about the officer's background, I want to take off my lawyer hat. I want to think of what about the person who's on the grand jury. And I talked to somebody yesterday, I don't want to say it because of secrecy. I said, hey, I'm doing this panel tomorrow. And she was like, hey, I was on a grand jury once. And I said, okay, tell me what you're allowed to tell me. Don't tell me specific cases and things of that nature. And she's like, yeah, it was just so easy to indict the people. You know, the DA gave us everything and we just indicted them. And yeah, we're going to believe the cop. You know, why wouldn't you believe the cop? I mean, that's what she said, right? And just think about that for a second. All right. And so, what if she had known more about the cop, right? What if she had known the cop's background? Would they have been so quick to believe the cop?
You see, but the difference also there, Attorney Boyle, is that when we do trials, the jurors are weeded out. If they have some empathy or sympathy or side with the cops, police officers, they're weeded out of that process. That's not happening in the grand jury. And you do have people that actually sit on jurors that have their own motivations and their own motives. And they're not always extremely very forthcoming as to where they may think of. And most of us have police officers in our family, you know, and watch Law and Order like I have been watching the marathons quite often. So it becomes very, oh, I'm going to side with the cop. So yes, the 50A, it would help because again, it will show the officer's credibility and his or her ability to quote unquote do right by society.
There are 10 police officers, if I may, in New York, 10. Amongst them, they have 287 pending lawsuits in city, in state and federal court. 10 officers with 287 pending lawsuits against them. 8 of them are Black and Latino, 2 are white. 1 is a union delegate in the DEA, the Detectives Endowment Association, and the other one is a sergeant. That is just 10. They are primarily in the Bronx and Brooklyn Narcotics Division. They are still arresting people. So 50A would tell a lot to a defense attorney for anybody who is representing a client arrested by any of those 10, and that's just 10. 287 lawsuits. But this is not being discussed, and the police department generally is not allowing that information out. And that's a crime wave on the people of the city of New York.
So let me comment a little bit about my experience in the grand juries. As I indicated, we've put 23 cases in the grand jury, and we were successful 17.5% of the time. And this included 1 manslaughter case, attempted murder case, and other cases. And this is after preparing a witness to put in there, and you as a lawyer don't get to ask any questions. Grand jurists listened. I couldn't, and the only reason I'm commenting now is because of my experience and having presented cases and as a prosecutor and having presented cases there as a defense attorney. They listen. They ask very probing questions. The standard is very low. Anything over 50%, there's an indictment. So to secure a no true bill before a grand jury, you have to scrutinize that process very carefully. But they do listen. And I remember I was a prosecutor after the Amadou Diallo incident. It was street crime unit that, if my memory serves me correctly, that did that horrendous act. When we sought to present a case with a police officer, and you start out by asking, by whom are you employed? Employed in New York City Police Department. In what capacity are you employed? I'm a detective. Where are you a detective? I'm with the street crime unit. My experience and my memory tells me that the jurors were immediately turned off by that. They became a very serious lightning rod as a part of the checks and balance in our system. So I know there are cases where there are just horrendous things happening, and I can't say anything other than that there are bad things happening. But I couldn't, in fairness to grand jurors, say, well, they don't listen and they don't ask probing questions. They really do. And they take the job very seriously. And if you have a case where it's questionable, whether it's police conduct or not police conduct, they will return a neutral bill, because I've seen it. As I said, my law partner hung a grand jury out in Suffolk County, New York, where we only had one witness, because how the system works is you present, your client's allowed to testify by virtue of law automatically if he or she is the subject of the grand jury after he or she has been arrested. But to call any other witnesses on your client's behalf, the grand jurors must vote to determine whether or not they're interested in hearing that witness. We present our client to such a capacity that we say, okay, you have to testify in such a fashion that it will intrigue the grand jurors to want to vote to hear from other witnesses. And we are successful in it. And I don't say that out of arrogance saying we are great lawyers. That's not the point. It doesn't matter how great a lawyer you are or not. If the grand jurors weren't open to that concept, it just wouldn't work. And finally, as to the police officer's background record, my hope is that our society strike the balance, regardless of where we live. And I've talked to young people a lot and said, look, if we're all, there's a lot of racism and things of that nature taking place in America today. But in the hope of striking some balance, I say, particularly when I speak to minority young people, I say, look, if we all lived in Africa and everybody's in charge, we're all black people, we would still have to build a jail. Because there's some people in society, irrespective of where they live and who they are, that will violate the law.
Right.
So we have to come up with a system to say we want good police officers to arrest the people who are violating the law, and at the same time do so by respecting people's rights. So if we have that as the measure, and we say we open up the system to every allegation against police officers, we allowed that before the grand jury, or we allow that at trial, then we might create a system where it has diminishing returns. Criminal defendants, it's only the arrest and the conviction that gets before a regular juror, and also before a grand jury. So if someone's been arrested 50 times and exonerated 40 times, and they ultimately pled guilty to, let's say in New York, we have what's called 240-20, disorderly conduct. So you charge someone for an horrendous crime as murder, and when it's all said and done, the person ends up pleading guilty to 240-20 disorderly conduct, which is not a crime. You get to apply to the court before trial even starts, because it affects your jury selection, the whole process, as to whether or not that 240-20 question be asked of your client if he or she were to take the stand regarding that 240-20. Guess what? The 49 other arrests where he or she was exonerated, they are innocent, and it doesn't go before the jury at all. So I borrowed that system for the police officers. Allegations with police officers are founded where they go before an administrative proceedings. In New York, we go to One Police Plaza on the 4th floor. They have hearings there every day. It's open to the public. I would recommend people take advantage of it. They try them there, and they go on trial, and some of those allegations are founded and some of them are not founded. The ones that are founded, I think it's fair game. But the ones where someone levy an accusation and allegations against a police officer and it's not founded, it wouldn't be fair to that police officer and to our system, just as our criminal record, a criminal arrest of someone wouldn't be fair to that person. So I try to strike a balance in this whole approach. And I try not to let the wrong that I see overwhelm the thought process. Because Mr. Boyle said, as a lawyer, you think differently. And I try to suggest that we try to think through analysis and not necessarily see with our eyes only, but see through analysis and try to hear through analysis. And I think that becomes helpful, because if we put it over on the other side, I have clients that have been arrested 10 times. And we put them before the grand jury. I don't want the prosecution to ask them about the 10 arrests when they were acquitted of those 10 arrests. If they got convicted of one, then I think we didn't measure. And we have what's called the probative value versus the prejudicial effect. So the standard when you have a criminal defendant accused of something, you say, Judge, listen, the probative value of letting this evidence in is outweighed by the prejudicial effect. And this is how it prejudiced my client. So let's say you're trying a case where someone's on a gun case and the person has 2 or 3 prior gun convictions. Well, if the judge allows the prosecutor to ask all those questions about all those 3 or 4 prior gun convictions, then chances are you're not going to get a not guilty verdict on this one pending gun case. And the person could have 3 prior convictions for a gun case where they're in fact guilty, but be innocent on this one. So in a situation like that, you advance an argument, Judge, this is so prejudicial. You can't allow all 3. And in many instances, the judge in a situation like that says, okay, I'll allow one question to be asked if the client testify. Have you ever been convicted of a felony? And once the person says yes or no, the prosecution is barred from going any further. There's a balancing in place. And so we have to remember that, look, grand juries are just like me and you and regular folks. They get there and they listen to stuff and they ask questions and they will return a no true bill. The system works from my experience with that. 23 cases in, 17.5% of the 17.5 times means we have more than a majority success in that area. So I couldn't
Thank you,
sit by and let
Attorney
that-
Drummond. I know
Yeah.
that this is very
Yeah, we're
important
over.
topic, and we will be conducting more forums. We know that is needed. So for the lack of time, we have to wrap up this forum today. And we really appreciate all of you to come in today and educate the public. We will be sharing this video for those who were not able to view it, but I know it was on Facebook Live. So again, I thank you so much on behalf of the Amadou Diallo Foundation. We are going to respect everyone's time, especially our guest speakers, because we planned this for until 1:15 and we are now at 1:24. So we're gonna wrap it for 1 minute. Each one of you to close it. Thank you so much.
It's been great.
Thank you very much. Thank you very much for coming. Hope to see you soon.
Yes, and I think
You,
today
everyone.
was wonderful. The more we get the information out, the better. If everybody heard everything today and passes it on to 10 people, because the information today was amazing from the other 2 attorneys. Not saying myself, the other 2 attorneys were amazing. And if we can get that knowledge out to 10 people each and each, so people are not getting their thoughts about how to reform the system based on Twitter, but they're actually getting the knowledge. If you know the system, then you can fix the system.
Kevin Boyle?
Susan, do you have any comment?
I just wanted to say this was a fantastic forum and each of us must pledge to bring the content of it to 10 more people. I agree with Kevin Boyle.
Thank you so much.
Thank you.
I want to thank you for having me be a part of this forum. I think it's just dynamic to be able to get the information out. And again, thank you, Mrs. Diallo, for this.
Thank you. We will be sending out some information about the next forum soon. And we thank our moderator. We thank all the guests. Thank you so much. God bless.
Thank you.
Thank you.
Have a good day.
Thank you.
Thank you
Thank you
all.
all.